Good evening, all. Hello, Unniti madam.
Yes, sir.
Just I was checking whether the sound is audible or not.
Yes, sir. Sound is audible.
Okay.
Sir, within 5 to 6 minutes, we will continue with the lecture. We will start it. Okay. I'm waiting for students. Let them join, and then we will start. Good evening, everyone. Am I audible?
Yes, madam, you are audible.
A very good evening to everyone. Myself, Professor Unnati Jadhav, and today I welcome you all in this 9th lecture of lecture series. I would like to welcome respected Advocate Shri Ashish Ji Bajpai sir, Principal of our college, Dr. Poonam Nathani madam, all the faculty members of our college, and my dear students. Today's lecture series we are having on the topic of law and language. It is an interesting topic where a well structured legal system which is supported by a clear language which is essential for an equitable and just society. So for this lecture series we are having with us today Assistant Professor Pravin Sawargavkar sir. Sir, I request you to take a charge of today's this lecture series. Over to you, sir.
Yeah. Good evening, all. Guten Morgen and bonjour. At the outset, very good morning to good evening to respected Ashish Ji Bajpai sir, respected Principal Poonam Nathani madam, all my dear colleagues, esteemed colleagues, Coordinator Shubhangi Panchal madam, and all. Once more, I wish you very good evening. At the outset, I said Guten Morgen and bonjour. I know that very few of you are able to understand what do I mean to say, that is Guten Morgen and bonjour. Instead of taking your much of time and rather increasing your curiosity, I will tell you. Guten Morgen is nothing but a German way to express wishings, and bonjour is nothing but a French way to wish each other. This is what the Guten Morgen and bonjour is. Now, when it was decided that we will have one session, or when Ashish Ji Bajpai sir said that every lecturer should share whatever they want to the lecture series, and Unnati madam said that this is the 9th one. But when it was declared that there should be the lecture series, spontaneously I said to myself, rather spontaneously, that it should be only on law and language, or rather language and law. If I'll be given chance, I'll speak on law and language. For that, there are two purposes. Before going for that purpose, I'll tell you what I want to say is, there is one subhashit in Sanskrit that Shateshu Jayate Shura Sahastrechu Pandita Vakta Dasa Sahastreshu Data Bhavati Vanava. And I'll tell the meaning of it, that if you want to find the brave, the courageous person, you will find it in 1 among 100. If you want to find a wise person, you will find it in 1001. But if you want to have the best orator, that is Vakta, it may be among the 10,000th one, and the donor is very rare to find it. I'll take the opportunity to change this subhashit a little bit. How a little bit? Shateshu Jayati Shura Sahastrechu Pandita Adhivakta Dasa Sahastreshu. Just instead of saying Vakta, I'll say Adhivakta Dasa Sahastreshu. Or even in other words, I will tell that not only Adhivakta Dasa Sahastreshu, but Adhivakta Bhavati Vanva. What this Bhavati Vanva? You will find a strong person, a courageous person among 101, a wise one amongst 1,000, and an advocate is very rare to find. That's what I want to say when I am saying Shateshi Jayati Shura Sahasrechu Pandita and Adhivakta Bhavati Vanva. So this is what I'll tell why I'm saying these things. I'll give you two anecdotes, but before going to anecdotes, I want to give you one very simplified thing, that what Adhivakta is and why had I chosen the subject called law and language. That when Abraham Lincoln was talking about the lawyers, he says that as lawyer, what we do most is we write. Lawyers' time and advice are our stock in trade, but we express the advice in word, and we use our time in drafting, in communicating mostly by the written word. Sometimes, though we fail to remember the first object of writing, to communicate. This is what Lincoln wants to say, or this is what Lincoln said. I said that I will give you the anecdotes, that why I had chosen and why I am saying that Adhivakta Bhavati Vanva, that Adhivakta is very difficult to find. There are two reasons. The first reason is in 2020. But what happened in 2020? That a Delhi-based lawyer, Subhash Vijayaran, filed a public interest litigation regarding the problems of lawyers. What was his problem? In a writ petition, he stated that the writing of the most of the lawyer is either wordy, unclear, pompous, and dull. I repeat that in 2020, a Delhi-based lawyer, Subhash Vijayaran, filed a public interest litigation saying that the lawyers are facing problem because of this quadrangular thing. That is, most of the drafts are, most of the litigation is regarding the writing of the most of the lawyer is very wordy, bombarding, unclear, pompous, dull. Now, I and my friends said that whether you are agree or not, we use many words to say what we can be said to. We use archaic phrase, and many of the things. This was the first anecdote which I am telling. Anecdote, that is a referential term, a referential story, as far as what I want to say through anecdote is. And the second anecdote or second reference I want to give is that in 2017, the Supreme Court had to set aside a judgment of Himachal High Court due to the excessive use of jargon, rendering the judgment and incomprehensible. The Himachal Pradesh High Court ruled and said the very lengthiest judgment, it was a pompous judgment and all. These were two anecdotes, and this is what my today's topic is. Now, what is the relation between law and language? Now, I joined law, as far as my personal experience is concerned. I'll tell you, when I joined law a little late. Only I knew this Bonjour, Guten Morgen, or I knew some of the world-renowned statements like of the Julius Caesar, that this is the most unkindest cut of all and all and all. Only this one. But I was a teacher by profession till 2018. I never get to lawyer. My neighbor, there were no one who is my neighbor and advocate. That the profession of advocacy was from me. In my family, there was not a lawyer. But somehow, when I was doing a job of teacher, I encountered with a case, and I had to attend that case as a teacher, rather as a representative of a teacher. But when I attended the court, particularly the bench of High Court at Aurangabad, I attended the court. Yes, the words or the manner in which all the judges were speaking, there were too many bombarding language. Means this, what not, prima facie and all, what not they were speaking. I thought that it was a good thing that I never joined law. But as I went into the studies, as I study, I thought that yes, this is a very interesting area. This is very interesting domain. How interesting domain? Why everyone is frightened of the lawyer, or why did I say that a good lawyer, it's very hard to find? It's vanva. A good lawyer is very, very extremely hard to find. Why? Because the communication of law is as important as determining the justice. How determining the justice? It is nothing but that it is this recognition is important. This recognition is imperative to ensure the integrity of our whole legal system. You will be given chance if you want to ask anything, you can ask it at any time. But try to get your concept clear, as I'm getting my concept clear, that whenever we are speaking of the law, it is very important to communicate in the legal language. This recognition is imperative to ensure the integrity of legal system. We have seen how regional language, also Hindi, have been marginalized, not by giving prominent place in any of the law. In this, now we are celebrating 75th year. Rather, we had completed 75. We are celebrating 76th year of our Indian Constitution, and even in Indian Constitution, when we are celebrating, we are not able to give justice thoroughly in the regional languages. This complexity of statutory language has made the legal system incomprehensible. Why incomprehensible? The linguistic barrier is the area of concern in India with respect to accessing the law. Now, why everyone is frightened to say that if you are stepping to the court, it is very difficult. And the last resort is the court. Why the last resort is the court? In the as the routine of the lecture, I'm telling you some of the things regarding the complexity. This linguistic barrier is the most important concern in India. Why? For the accessing the law, not only accessing the law, its procedure and adjudication. The language barrier limits the understanding and lay regarding its rights, exhibits the lack. It seems that it's a very, when we are talking about the law, we feel that it seems very tedious and verbose. It becomes extremely difficult to understand what the lawyer is saying. Now, when I joined this law teaching as a career, and when I entered into the class, and when I'm speaking all this linguistic diction, what I want to say it as a diction, linguistic diction, I saw that the faces of all students are in a different way, that they are not getting me. But whenever I am speaking in Marathi, they are getting me, or either in any regional language, they are getting me. They are thinking that just I am speaking their own language. But it is fundamental. At that time, I felt that it's a fundamental contradiction at the heart of democracy. Why at the heart of democracy? On the one hand, we say that there is a rule of law, and it is supreme. It's a supremo. Everyone has to obey the law. and everyone has to obey the law. And for the first time now in this lecture, I am using one maxim, that ignorantia juris non excusat. What is this? One, I say rule of law, and how contradictory we are speaking, that ignorantia juris non excusat. It means that ignorance of all law, ignorance of law is no excuse, because law considered to be knowable and understandable. Do you understand? What I want to say is that we are living in a ironical situation, a contradictory situation, that at one hand we are speaking of rule of law, and at the other hand we are saying that everyone should know the law. How will we come to know about the law? Now, earlier, I had brought one book called as a Manusmriti. In that Manusmriti, there is 8th adhyaya. Even while dealing with this language and law, I thought that the language which I am using as far as the law is concerned, was it the same when Manu wrote about the law? The 8th section is about the law and Nyaya, and the 8th adhyaya, not section. 8th adhyaya is regarding the law and all. Even that, when I was reading all this, either in Marathi and Sanskrit, I never find any integrated language in it. Any the diction which was used there was very easy. Then why can't we use the easiest diction whenever we are using the law? This is my first question. Rather, this is my first concern. Just I want to ask one thing to Honorable Ashishji Bajpayee sir, that are you agree for this statement that we are living in a contradictory situation in rule of law, and the second one is ignorantia? The rule of law, and second one is.
You continue your lecture.
Okay, okay.
Whatever you have to express, you express. Later on.
Okay, sir. Okay, sir. So, ignorantia and all. Knowing the law that allows people to protect themselves. We know that the law allows people to protect themselves, assert their rights, and seek justice when they have wrong. Laws are not written to be exclusive, niche product. They concern everyone in India and are applicable to every and everyone. Rather, everyone. I'll say it says everything. Indian laws have been criticized for many for many people for their complex drafting. I will give some of the examples here, which makes them difficult to read and understand. And just see any judgment, that's the judgment is the biggest one. I'm giving one example here, that it's difficult. There is no reliance on archaic drafting elements such as proverbs, notwithstanding clauses, gender and non-exclusive terms. And the use of foreign terms, it is very accumulated baggage of words and conversation that's just we conversation gathered and retained over centuries. To this extent, English is used by the professions and is considered different from the common speech of English. The legal English is different, and there's common English. It includes not only distinctive words, phrases, and expressions, but also the manner of composition. This combination forms what we call this as a language of law, and that is associated with law, the courts, and the course of profession. Complex legal drafting goes against the gain of democratic and participatory society, as it reduces accessibility of the law to the common man. Now, the language of law, afterwards we are going what is the language and what the language of law is. The language of law is supposed to be plain in order. What the motive of my language is, it should be very plain in order, to leave no room for some ambiguity, the dual meaning. That is what it should not leave any room for ambiguity. That in last lecture, when I was listening to the earlier lecture series, there were the dilemma regarding culpable homicide, non-unculpable homicide, then motive, intention, and all. There was just a slight difference in it. So that's why I always feel that it should be supposed to be plain in order to have a room, no room for ambiguity and for proper understanding of the people. It has been joked upon the lawyers that the minute you read something which you can't understand, you can almost be sure that what is drawn up by the lawyer. There is a very famous example regarding it. I'll tell this famous example in both the languages. It's not language actually, it's a language, both the languages. Take the following, any case drafted by an English critic. For example, when an ordinary man wants to give orange to the another, he would just say, if an ordinary man wants to give an orange to another one, he will just say, I give you this orange. A pen, whatever it may be. I'm taking the example of orange only. I give you this orange. You may do with it whatever you want to do. Finish. An ordinary man. 10 years before, if I would have been just a teacher, I would have been said, I would have been said to a person that I give you this orange, you may do with it whatever you may please. But when a lawyer has to do the same, just listen, when a lawyer do the same, when a lawyer do the same, he will say in a different manner. He will say it in a different manner. I'll tell what will he say in a different manner. What will he say? He may say that in this way, know all men. He will start. All lawyers, just imagine you are drafting, and when as the budding lawyers, that is the student, just see how the barracks and everything is written like this. Know all men by this present that I hereby give. Know all men by this present that I hereby give. One, grant, bargain, sell, release, convey, transfer all my rights, title, interest, benefit, and use whosoever in, of, and concerning this otherwise known as an orange. This is half one. Or citrus aurantium, together with all things thereto of skin, pulp, piperine, seeds, and juice for his own benefit to himself, and has in fee simple forever, free from all liens, encumbrances, easements, limitations, restraints, or condition whatsoever, any and all prior deeds, transfer or otherwise documents whatsoever, now or anywhere made the contrary, notwithstanding with full power to bite, cut, suck, otherwise eat and said orange to give away the same, with or without its skin, pulp, piperin, seed or juice. Now, this was whole Ramayana is. Now, what this was whole Ramayana, just for the sake of joke, I had said that this was just whole Ramayana is. We are habitual of, we are living in such a society where there is one shloki Ramayana, where there is one slok Ramayana or just we are making it abridged. And this lawyer is saying all these things when I want to say that just this is my orange, or I give you this orange. You may do with whatever you may please. This is the simplest thing. Don't you find that this is a very complicated one? And there may be some reason that why this has become very complicated. That's why many of the people, many are not going to the lawyers with a clean hand, with a peaceful mind, and also these are some of the reasons. Now, what should we do for that one? We should do for that one is, or this had become very complicated because we are learning a law which has come from rather Britishers, and everything in this 75 years only, everything whatever are our customs, traditions, and all, we are learning in their language. I am calling this as a foreign language. Now, this is just a slide in PPT that a foreign language is a prerequisite for most comparative law, and that the language is the jurist's most important instrument. Now, I had given you the example of one jurist here, and even though I am saying that language is the jurist's most important instrument, but the subject language has even wider implications and leads us to ask whether and to what extent a particular language makes an influence on a particular law. Now, it is obvious that we do accept that the law is not in our language, law is in foreign language. We do accept, and it's a jurist's most important instrument, but the language has more wider implications. How the English law was tough and impervious to foreign influence because it was highly technical. When I was giving this anecdote of a lawyer, he had used many technical words in it. It was highly technical because English lawyer had been able to make a vocabulary to define their concept, to think sharply as the man of science thinks. Think sharply as the man of define their concept, to think sharply as the man of science thinks. That is why we should also consider the close relation between rhetoric and the law. I repeat, that is why we should consider the close relation between rhetoric and law. In the beginning of the modern European culture, there were two books, one by James B. White, The Legal Imagination, and by William Bichet. Christopher, The Law, Language and Ethics, lead us to similar direction. This brings to a central problem. What is the influence of language on law? Is the structure of law a function of a structure of language, or more precisely, does a particular language create a particular law? Now, for that purpose, I want to give you two more references. What I had said it now. I'll repeat. It's an important one. That's why I'll repeat it, that we should also consider the close relation between rhetorics and law in the beginning of modern to European legal culture. There were two books, one by James White, that is Legal Imagination, and one by William Michel, Law, Language and Ethics. These two books lead us in a similar direction. Now, what is that direction? That it brings us to the central problem. What is the influence of language on law? Is the structure of the law a function of a structure of language, or more precisely, does a particular language create a particular law? There is a book by Modi, that is 10 Judgments That Changed India. What she has written, now everyone knows about the 10 judgments. If you go to Google, you will find all the judgments in a bombarding manner and all. This is a simple, it's not an abridged book. It's a simple book. I call this book as a rhetorics. How rhetorics? It has some different sound. Not only this example I will give of Jia Modi, but I'll give you one more example which everyone knows. Everyone, the one who has chosen the lawyer's profession or law as a field, he knows the roses in December. Whenever you are reading the roses in December, from the title itself, it's a figurative one. Whenever you are reading, you think that it's not written by a lawyer. It's written by a person who is more than a lawyer and who wants to convey the lawyer's sentiment in a different way. Forget about this roses in December, Jia Modi's 10 Judgments That Changed India. I'll tell you the other book by Fali Nariman. Forget about Fali Nariman. But when Gandhiji wrote My Experiments with the Truth, even in that he had said, even one of the chapters, he has said that what is the role of law and what is the role of language when we are convincing it to, when you are convincing it to a client. Now, he has used a word. Nowadays, this terminology has become very popular. Which word or which terminology he had used? It should be users friendly. The client, even the ordinary client, should know what the judgment is, what the lawyer is, what is written. Now I'm giving you too many examples, and some of the maxims which we are using. But in the case of 2020, the Delhi-based lawyer, when he has submitted PIL, when he has made PIL, he said that now this is very integrated. Who will join the law if you are finding such things in it? Not only this, but prior to it, in 2017, a judge of Supreme Court has to find out, or they have made certain findings that the judgment of Himachal High Court is so bombarding, so pedagogical, that it has not become a legal document. We are learning it in a different way. Now, what would be the solution for it then, if it is bringing it the structure of law, functions of the structure of our language, or more precisely, does a particular language create a particular law? In order to tackle these two provocative questions, let us first consider the status of language. This evaluation takes us back to
Sir, sorry for the interruption. You are not audible, sir. Please unmute yourself. Yes.
Shall I repeat what did I say now? Or shall I?
Sure, sir.
Okay, I'll repeat.
Last sentence only.
Okay, I'll repeat so that even everyone will be in connection, because if even one thread is loosened, it will have a different impact. Now, what we were dealing with that, dealing with these three problems. The first one was that what is the influence of language on law? Is the structure of law a function of a structure of language, or more precisely, does a particular language create a particular law? So in order to tackle this one, we have to go little bit deep, that even in when I'm giving example to student, that I give one example to student, that this part of our body, we call this as an Adam's apple. Why not it is Eve's apple, or why not something in a different way? So the Bible or this Adam has given names to many things. So that's why language is not only a means to comprehend the world, it is even means to recognize it. It is a mental device that enables the mind to comprehend what it sees. This brings us back to Bible. This is fiat lex I had given the word lex. So that's why at last we say that, it's not last, at last we say that the creative and comprehending power of language of a special importance for law, there is practically no existence of legal notion outside the language. One commentator has said that. Now, rather one commentator, it is in Gandhiji's book also, it is on the loom of the language that all law is spun. It is the loom of the language that all law is spun. At least the positive law is bound to language, because its legal notion exists only in language, and through language, law is expressed in a verdict. In legal language, I am saying that it's a Varnum decree and is connected with jurisdiction. Nevertheless, one should not go so far as to conclude that there is no law outside the language. The existence of customary law contradicts such a statement. Customary law is often comprehended in the word, but express itself in a particular situation. So only I'm giving you. So as we saw three questions, there are two functions of the language, that the language of the law attains correspondence to our internal structures. I know our basic questions are something different, that the language of the law attains to the correspondent to our internal structure. The language aims to strike a chord in us as the rhythm of the music invites, of a drum that makes us a soldier march. It's a rhythm, and its sound stimulates us to internalize the law. The language uses the genetic cultural sensibility for the purpose of the law. We follow the law voluntarily as a part of ourselves. The law is observed not because we have to follow it, but because we want to. Now, and furthermore, I'm expressing this one, and I'm trying to tell you what I said it now. I tell you once more this one. We follow the law voluntarily as a part of ourselves. The law is observed not because we have to follow it. I repeat, the law is observed not because we have to follow it, but because we want to. Instead of solemn sorang, that is external order, we are having it. It comes, or it constitutes a Wallen Sohang, that is internal order. Wallen Sohang, that is what the internal order is. So it is not for the sake of external business. It is for just this law is for the sake of internal one. So this brings up this. I'm giving you some of the examples, and then we are going for the our main chapter. That this brings us back to the initial considerations, that we understand why the old laws were often use rhymes and rhythms. Law is that only orally transferred, has to be in much more sensitive language. Law can only be effective if it is followed voluntarily because of internal stimulus. Law that does not correspond to the linguistic sensitive, our law, but it's seen something foreign. That's why the magic of the language continues to be a central pillar of the law. It's a decisive factor in the legal organizations and societies. So only I've done some of the linguistic factors in it, that what are the what should, or rather what are the barriers in it. But our today's particular topic, or what I want to convey is, I said rather this, what I want to convey is that from ya rudi che ta rudi. I had not jumped when I went to slide from one slide to other slide to the next slide and all. What my problem is that, and why I want to get you in our conversation is that this one, language of law in India needs revitalization from complexity to simplicity, so that anyone can find it easy. What is our constitution saying about it? What are our own opinion it, and what you are voluntarily saying it to? I had given you example, some of the examples, that there is fundamental law and all, and I had given you one example of a lawyer, that if he wants to have the orange, what will he say? I will give you some the other things, that in India we find many common words with uncommon meaning. Even in slide, I have written something different, and I'm giving some different examples. That, for example, if my neighbor is saying, or I am for neighbor or for any common man, I'm using the word layman. If a layman says demise, demise. Now we are not going into the pronunciations. Just I am saying, to layman, demise means a person's death. Simple. But to a lawman, it means transfer of a property by lease. To a layman, to a common man, present means just gives. Present means gives. But to a lawman, it means this document. To a layman, that in last lecture also we had discussed, I heard it discussed, that motion means movement or process of moving. To a layman, it is just movement or process for moving. To a lawman, it means application in the court. To a layman, said means the past and past participle of say. PP, past participle, third form, past participle of say is said. It is an adjective for a lawman. For us, it's an adjective. How adjective? For example, the said building, said thing, that is, lawman use long sentences so that by the end of it, the reader needs another lawyer to explain it. I read it once more, or rather I will clarify it once more, that a lawman use long statements. Now I am using some of the long statements here now. Long statements. I remember when I made one application in the court, and it was a long statement and all. So a lawman use long sentences so that by the end of it, the reader needs another lawyer to explain what it means. In our legal system, we use words which are antiquity, which go back thousands years and are not in current general use. Words such as aforesaid. It's an archaic word. Why are we using aforesaid? Now, I have only one or two are the language. Why do we use aforesaid? Can't we use as far as the English is concerned, these things are called as the discourse markers. So it's a different one. Discourse marker is a very important term in lexicon, what we are calling as a legal lexicon, what we are calling as a language. Afterwards, I will tell you what is lexicon, what is lex, and what is legal. But here, we stick to ourselves only one thing, that the lawmen use long statement that we need one more lawyer to explain it further. It's that there are certain words, as I said, aforesaid, forthwith, henceforth, thenceforth. Sometimes we use multiple words to convey an idea where one would do. We will say null and void and of no effect whatsoever. Null and void and no effect whatsoever. Even just void or null can do it. Loan words are borrowed from other language. The need for these arose as an England French language. That's why intentionally, deliberately, I had wished you in a French language. Bonjour. Bonjour is nothing but good evening. That's why. So our legal language, what we are learning it now in India, is the need for those arose in English and French language were considered vulgar and deficient in a logical expression. So not only vulgar, but English and French were some of the rustic languages. So very soft language, rather. Just for the sake of your understanding, I'm using the word called soft language was used. That was a Latin language for the law in England in 1066. Thereafter, variety of Latin words, that is known as Low Latin words, are used. Most of the words still prevalent here. I'll tell you some of the words, even you may know it. Why are we using, now I know, or just I'm justifying why am I using this one, but we use ab initio. Initio, they are saying that, ab initio. Why are we using ab initio? There is one more Latin word, ex parte, res judicta, prima facie, habeas corpus, certiorari, qua warranto, ex post facto, de minimis, in personam, mens rea, peri passu, res judicta, quasi are generally used in law. Everyone cannot expect to be proficient in Latin. We use argot. There is one word, never forget this word called an argot, which linguistics describe as a slang or jargon in profession. It is some form of language of the communication within the group, sometimes deliberately designed to exclude a technical specified set. Here is a sampling at this issue. Case of action. 4 concerns of the instrument and all. Time is of the issuance without prejudice. These are some of the discourse marker I'm using. This is daily staple of legalese or jargon. We still use words which are ceremonial in rituals, like when we are in front of the judge, we say, Your Majesty. Likewise, there are too many words. This is daily use. Words such as Your Majesty and other. We still use Your Majesty of the law bit. Many of these constructions as words are most peculiar in languages of law. Likewise, most respectfully showed. Why showed? Why not show? Why showed? To all to whom this present come. Greetings. Know all men by these presents, that whomsoever it may be concerned. Then this is what. Know all men by this present, for such other and further relief, as which this honorable court may deem just and proper to meet the ends of justice. To me, if thing can be told in one sentence, just all things we are doing, this too many things and all. Just I'm tempted to give one example that in English or any communicative language, there is very easiest way that if someone has cheated, we say, Brutus, you too. It's a dialogue of Julius Caesar, a very well-known drama. Or even if your friend had cheated, you say this. You say like this. This is the most unkindest cut of all. Why the most unkindest cut of all cheating? For cheating. So why are we using all shoth and all, and an honorable court may deem just and proper may it please the court. Now for adjournment, always we use may it please the court. The truth, the whole truth, and nothing but the truth. Truth, whole truth, and nothing but the truth. So help me God. Prior and instant. In simple terms, the language of the law is full of long sentences. I'll tell you now the problem. I'm discussing it again and again. It's not only long sentences, awkward constructions, fuzzy words, as I had used these words, shobit and all, these fuzzy words. Some critics have suggested that the long retention of the legalized is not just due to professional general conservatism, but comes out what might be called, now just see, I'm using the word and very responsibly I'm using the word. I know that the lawyers community is listening to me, and with a very responsible manner I'm using this terminology. Why? This is not because of the proficiency. Now whatever the words we are using, it not just because of, some critic has suggested that long retention and all these is not just due to profession's general conservatism. It is not just the profession's general conservatism, but it is for a different one, as suggested by David Melinkoff, who wrote a classical critique of the language of the law. What better way preserving professional monopoly is that one, that legal profession, but comes from what might call conspiracy of gobbledygook. I'm using the word once more. So it is not because of the what I had said it earlier, that professional general conservatism, but it is because of conspiracy of gobbledygook. I will tell you what is this gobbledygook. It's conspiracy of gobbledygook. It's just, that's why I am using video only for only for this terminology, gobbledygook. Justifying fees is not the only reason for the persistence of legacy. Their distinction language allows lawyers to mark themselves as a member of profession. And then there are these 2020's case and 2017's case. Now, there are certain reasons for the complexity. Legalize is a special language which differs from common language and using the use of Latin and sometimes French words and phrase expressed to rule, principle, doctrine. Actually, I wanted to give many more examples of this one. The phrase English, we use absolute, archaic, passed from English language but have been kept alive by their frequent use of legal professions, use of argot, practice of assigning common English word, new, different, unusual, and purely legal meaning assigning these words. Some exclusive legal definitions and ridiculed tendency of legal professionals. Now, why do I want to simplify it? Why I don't want to use the ab initio and what the bombarding words I used earlier? The plain language statutes and documents are more efficient. First one. So some of you can ask me this question. Okay, why are you saying all these things? My very plain objective is that, my sole objective is that the plain language statutes and documents are more efficient. They are easier to read for both lawyers and non-lawyers, saving time for lawyers and non-lawyers. Plain language documents are easier to read. The queries about meaning are reduced. Plain language enhances the image of legal professions. I repeat it. Plain language enhances. I repeat and say it loudly. Plain language enhances the image of legal professions. The absurdity. There are many absurd words. The unclear, that is what absurdity, of whose traditional language has long been source of ridicule one. You might have heard many jokes regarding lawyers' conversation. As it was a type of joke only when I said regarding orange. When I said regarding orange, even I give some of the parallel jokes as that orange thing also. Even when an Englishman, non-English man is talking to an Englishman, he may say that I have 2 daughters, both are girls. Actually, I'm joking when I say this, that I have 2 daughters, both are girls. Likewise, so the lawyer's profession is ridiculed. If we are using plain language, it will enhance the image of legal profession. Obscurity of whole traditional language has long been source of ridicule, and quite apart from absurdity, legal writing is impersonal. It creates barriers of aloofness. It intimates the readers and keep them in the dark. In a word that has increasingly prioritized of the demarketization of access and all. So as far as these objectives are concerned, so these were some of the adjectives. Now, you may watch it to the slide here. I have written the constitutional provisions on language. I'm jumping a little bit more because of the time constraint, and much can be talked about it. But what our constitution is saying, when I was trying my best to make it simplified out of complexity, what the provision related to the language are included in the part 17 of Indian Constitution. Article 343 to 351 deals with the official languages. Article 343 deals with the official language of the Union. It states Hindi, Devanagari script. 345 deals with official language of the state. Article 340 provides the legislature of the state may, by the law, adopt any one or more of the languages in the use in the state or Hindi. At the end of this lecture, you can say that is there any judgment decree which is in Konkani language or not? Afterward, it's a different part, but just I'm giving you the constitutional provisions to be used for all in official. Article 348 of 1 of the Constitution of India provides that the proceeding in the Supreme Court and each High Court shall be in English language unless the parliament provides otherwise law. 342 allows governor of state with the previous consent of the president to authorize Hindi language, or I don't think that this is implemented, authorize the Hindi language or any other language to be used for any official purpose for the state proceedings in the High Court. The Article 351 gives special directions for the development of Hindi. It says it shall be the duty of Union to promote the spread of Hindi, to develop it so that it may serve as a medium of expression and all. Hindustani and the other language in India specified in the 8th schedule, and by drawing whenever necessary or desirable for its vocabulary, primarily on Sanskrit and secondarily on the other language. I took a pause deliberately here. As a result of Munshi Iyengar formula, its schedule was formulated. It contains 22 languages. The last 2 languages added as in the 92nd Amendment. The Constitution protected scripts and the languages under Article 29. It prohibited discrimination on the grounds of the language under Article 14 and 16. Under Article and 16. This was what about law and languages. Much is to be said about this one. I had asked some questions to me, not myself, I am using the word, to me, that rather 3 questions to me. What were these 3 questions? Is the structure of the law, functions of the structure of our language. More precisely, does a particular language create a particular law? So to the central problem, that what is the influence of language on law? Is the structure of the law function of the structure of our language, or does a particular language create a particular law? This was what I want to say. I want to conclude with one saying which Pandit Jawaharlal Nehru used to say regarding this one. It's a Robert Frost poem actually. Woods are lovely, dark and deep, but we have promises to keep. Actually, when Robert Frost has written, he has written, I have promises to keep. Woods are lovely, dark and deep, but I'm using the word we only. We have promises to keep, and miles to go before we sleep, and miles to go before we sleep. I tried the best. Rather, I asked question to me and to you also, that these 3 basic questions regarding language and the law, rhetorics and all. This is what from my side is. I hope it was nothing but the what, as I said again, yardi che tyardi, and even there is one more word, satya satyasi man ke le gwahi, maniye le nahi bahumata. I repeat, satya satyasi man ke le gwahi, maniye le nahi bahumata. What I felt as not only language teacher but learner of a law, that the legal language should be easiest one, not easiest one, legal language should be easier one. That's why I said, and I once more said, that miles to go before we sleep, and miles to go before we sleep. This is what from my side is. Thank you very much for being with me. Thank you all organizers, particularly Honorable Assistant Vice President sir, Dr. Poonam Nathani Madam, Honorable Principal, Shubhangi Panchal Madam, Unnati Madam, and all my dear colleagues and my dear friends. Thank you very much. If there are any questions, you can ask me.
Thank you so much, sir. If any questions are there from the students, you can raise your hand.
Okay, no problem. I'll wait for their questions.
Yes.
Yes. I'll wait for their questions. Till then, they will ask the questions. Some of these words are for all of them, for all lawyers community. These are Marathi terminology. Actually, I spoke thoroughly here what the English which I knew. As far as words are concerned, the lawyers are concerned. आम्हा घरी धन शब्दांचीच रत्ने शब्दांचीच शस्त्रे यत्ने करू शब्दची आमच्या जीवाचे जीवन शब्दे वाटो धन जनलोका आम्हा घरी धन न्यायाचीच रत्ने न्यायाचीच शस्त्रे यत्ने करू. Instead of शब्द I was using the word न्याय. Whatever it may be.
Pancha madam. Should I conclude the meeting? Okay, so no questions are there. I would like to propose vote of thanks to Advocate. Sir, should I conclude the meeting? Just unmute yourself, sir.
Yes. I'm waiting. If are there any questions?
No.
Sir, I have a question.
Okay, yes.
In fact, I was just thinking about asking or not.
Just I want to request one thing that I'm not getting who is asking. Now it happens that you can just please do introduce and then ask so that I can give some of the anecdotes if I know some of the anecdotes up to your rather level. I should not say level, but which you know. Please. Yes, please.
Sir, I'm Dhananjay Zavlikar.
Yes. Okay.
It was a very excellent lecture, sir. Now, what I gather is you are basically opposed to the usage of classic language, which is being used in the profession of law. Is it correct, sir?
Yeah, it's not, I'm not saying it as a classic language. Try to understand what I mean to say.
Classical used. It is being used universally. Is it not so?
No. Which was the language of the ancestors and ancestors and why should I use their too and all this?
My point was, in any profession, when a technical jargon is developed, it is basically developed for the understanding, universal understanding of all the people, of all the world. I mean, you should there should be less scope to interpret a particular word in a different way. Is it not? So there are so many nuances while we use certain words. Now, if a classic language is being developed in a certain field of profession, that means it gives less scope to interpret it in a different way. So in that sense, the usage of Latin language in the legal terminology does give that scope to the usage of it. I mean, it justifies the usage of Latin phraseology or language, as you rightly put it. Isn't it so, sir?
Yeah. I got your point. sometime or when I was giving some of the examples in the class, as I had given the example that we had read one novel called Don Quixote, but the pronunciation is Don Quixote. I'll give you some the other examples also. It's not Montesquieu. It is not Montesquieu. It's just a Montesquieu. This, as far as this pronunciation is. Dhananjay, what I wanted to say is that we have to stick up what is tradition. As you are saying, that there are certain basic concepts. I have to stick up what are the basic concepts are there. But why are we not finding the simpler version for it? Why are we not finding? Just my question is that now this is a new generation. Find out the simple version for that. Instead of having some big judgments and all, just make it simplified. So I need not to hire two lawyers. One is for reading and the second one is for its meaning. This is what I simply want. Got it now? I'm not opposing its classical use. I'm opposing its archaic use.
You have a point, but then still it leaves scope for interpretation in different ways. Anyway,
This is what at the end I had ended my slides in the same way, that it is in continuation with, it has no end. Everyone has its own parts. It's a relative one. It's a relative. It will change from person to person. You will find some different changes in it. Unnati ma'am will find some different changes in it. Anchal ma'am will find some different changes in it. But Dhananjay, have you got it?
Yes, sir. We agree to disagree. Yes.
That's quite why just with a Japanese word, I'll conclude my arigato gozaimasu. It means thank you very much. This is what arigato gozaimasu is. It is used in one of our judgment. I will tell you, it is landmark judgment. The landmark judgment ends with this terminology, arigato gozaimasu. It's a Japanese term for saying thank you. Any other? No. Thank you, Unnati ma'am. Thank you.
So thank you so much, sir, for sharing your knowledge on the law and language are deeply connected with, interconnected with each other, as well as to understand the crucial role of the language in shaping interpretation as well as ensuring justice and making laws. Definitely, thank you so much, sir. I would like to propose my vote of thanks to Advocate Sri Ashish Bajpai sir, who continuously uh, support and encourage us to conduct such kind of different activities. As well as I would like to thank Dr. Poonam Nathani madam for all supporting us, as well as to all for the cooperation, and my dear students for participating in this discussion in this lecture series. Thank you all.
Thank you.